That was forensic video analyst Mark Messick on the stand. Much of that testimony ultimately occurred before the jury, in front of jurors. They heard it. They were told to forget about it. Francey Hakes is an attorney who joins us regularly here on the Law and Crime Network. She's back with us now to break some of this down. Francey, good to see you.
Good to see you too, Aaron. Thanks.
Okay, what do you make of this? I mean, this apparently went in front of the jurors, and then they were told to forget about it. Why not do an offer of proof outside the presence of the jury, have this guy get his expertise whittled down long before this point, and then have a clean trial in front of the jurors?
Aaron, this testimony should never have been elicited from this witness in front of the jury. It's obviously way outside his expertise, and as lawyers, as you know, we like to say, you can't unring a bell. Jurors are not going to forget what they heard. It could have an impact, and it is extremely unfair to the defense, I think.
I think that it is too. You know, I mean, I was always told to carefully monitor what's going in front of jurors and to lodge objections to make sure that jurors are hearing and seeing the trial that your side wants them to hear and see. So this is just a little bit bizarre. It's just not something that we're used to seeing.
No, it isn't. It's irresponsible, really, of the prosecutor, but also of the witness, who, as an expert in his field, should know what his field is and what is beyond his expertise, and he shouldn't be going there. It makes no sense at all.
Yeah, I mean, so to get an expert on the stand, a lot of times we hear and we think that it needs to be someone with 20 million degrees and all of this experience. It just has to be someone with experience, not necessarily education. I've heard of a case where someone was called in to be an expert about how to build a retaining wall, and it was someone who's a construction worker. It's just someone who has expertise or experience, I should say. That person can be certified as an expert. It doesn't necessarily mean a professor who's studied a subject for 50 years or something like that.
No, I think, Aaron, we've all seen My Cousin Vinny, which is actually a good example. When Vinny's girlfriend, fiance, got to testify as an expert in general automotive knowledge, if memory serves correctly.
Something like that, yeah. I mean, it makes it close enough. Bottom line, we are waiting for testimony to pick up in the Jason Van Dyke case out of Chicago. That's the case we're talking about now. It's the case of a former Chicago cop accused of killing a teen named Laquan McDonald. The officer's version of events does not match that squad car footage that we've been talking about. We will be back here on the Law and Crime Network with more live analysis when we return in a moment. Closing arguments are complete now in the Cody Lott murder case out of the Wichita Falls, Texas area. Jurors are getting the case. They're going to be on the clock very shortly. Francey Hakes is still with me here at the Law and Crime Network. Francey, you listened to the closings. What's your analysis?
Well, Aaron, I just don't see how the jury can possibly find Cody Lott not guilty by reason of insanity. I just don't think the evidence was sufficient. I think the evidence of his planning, of his actions after the crime, shortly after the crime, and then days after the crime, his inconsistent statements to police, all of which show a consciousness of guilt. I just don't know how he can possibly find not guilty by reason of insanity here in this case. We're
back into the legal definition of an insanity defense. There are four predominant theories. Texas does not follow one of the strange ones that only one or two states follows. It's pretty mainstream. So let's recap that. Why does that defense not work here, in your opinion?
Well, I mean, I think it doesn't meet the test. The defense has to prove, it's a high burden. The defense has to show that he was insane or incapable of understanding right from wrong and controlling his actions at the time of the crime. And at the time of the crime, it looks very much like he was in full control of his actions.
In other words, he understood right from wrong. He made a decision to follow a wrongful path of conduct. He borrowed the weapon or took it from his stepfathers, went to the scene. There was a lot of premeditation, I guess I could say here.
Well, there was a lot of premeditation. In fact, he admits to premeditation himself, although he says he planned the crime with the devil, but he still says he planned the crime, and he gives a motive. So this is not a case of insanity. This is not someone climbing the walls who doesn't understand what he was doing at the time or even now.
What do you make of the fact that the defendant had to be committed to some treatment before he was found sane enough to stand trial?
Well, it's a different standard, right? It's whether or not he understands what's going on in the courtroom so that he can meaningfully aid in his own defense. And I have no idea really what his actual mental condition is, but whatever he said convinced doctors that he could not assist his defense team. But now he can. So the law recognizes that he is competent to stand trial and can be held accountable for his actions.
I mean, competency can come and go in a case like this. So look, bottom line, jurors are going to be very soon on the clock in the Cody Lott case, if they're not indeed on the clock as we speak. They had instructions before closing arguments. It looks like that's where they're at right now. So jurors are going to be on the clock very shortly in that case. In the meantime, we're going to switch you back to the Jason Van Dyke case out of Chicago. This is the case of a former Chicago police officer accused of gunning down a teenager named Laquan McDonald. We're listening to some cross-examination, I believe, in this case. Let's go in for more. And we're waiting for testimony to get moving along again at full speed in the Jason Van Dyke case out of Chicago, the case of a former police officer accused of gunning down a teenager named Laquan McDonald. Now, we've heard a lot about the bullet trajectory in this case, and we were talking earlier about how that was an evidence dispute as to whether or not a video analyst could talk about the bullet trajectory. Earlier in this witness's testimony, we were listening when we were in the midst of the Cody Lott case, and they tried to get this witness, the defense, I should say, tried to get this witness to say that the fatal shot was a specific shot that was made when the victim was facing the defendant, but this witness wouldn't go that direction because what's contested here is whether or not the victim was coming towards the officer when the officer opened fire or whether he was turned and going away. So if the officer fired the fatal shot when the victim was approaching the officer, that could lend credence to the officer's version of events that this was somehow a proper self-defense. We are waiting for a sidebar to wrap up in this case. Francey Hakes still on the line with me here as attorneys take some time to talk with the judge about where they're going next. What do you make of this medical examiner's testimony? The defense really tried to pin her into what order specific shots could have been fired. It sounds like, well, medical examiners can't tell that. Medical examiners can just tell that a shot was indeed fired in this location and what caused death.
Well, Aaron, sometimes they can. It depends on, they can tell things like how much a wound bleeds, whether the heart had already stopped. So they can sometimes tell some order of shots, but you're right here. I don't think the medical examiner can tell because they were fired rapidly. This case is so distressing to me watching the video. It does not seem the police officer was justified in the shooting. I mean, you see the other police officers around him. You see police cars. He doesn't appear to represent a danger. However, I have to say that I find the slow motion video to be very unfair to the officer because it's not in slow motion that he's making his decision on whether or not he or the public are at risk. And in talking to a well-known former police officer, former federal agent, Tim Clementi, he notes several cases where police officers are trained that someone with a knife in just a few seconds can kill someone even if they're being fired upon. And so they're trained that when someone has a knife and doesn't drop the knife, that they're every bit as much of a risk as someone with a gun. So, I've never been in that kind of life or death situation. I really hate to judge not having ever been in that situation. But the video definitely is disturbing. And I think that there was a good reason to have a trial. At least the prosecutor's office thought so.
Yeah, I can understand that. And look, talk about the speed of the video. We've talked about this in other cases. We've talked about it in other police officer-involved shooting cases that we've covered, including one recently here. Watching these things go by in real time, when the video is played at full speed, it always surprises me just how quickly the events unfold. And officers do have to make those split-second decisions. They have to decide, am I at risk of being injured or killed, or do I need to take the suspect out? That's how it rolls out. We're back with live testimony, so let's go back into the Jason Van Dyke case out of Chicago. Taking a quick break there in the Jason Van Dyke case out of Chicago. Attorney Francey Hakes is still with me here at Law&Crime. So, Francey, they're really trying to dig into the order of the shots, which shots were fatal, What difference does it make in a case like this? Can you look into your crystal ball and try to help us understand why they're belaboring these points so much?
Aaron, I think it always has to do with sort of trying to glean motive from where the shots were, as if the officer might have been firing at a particular part of this teenager's body. Did he go for the legs? Did he go for the head? Did he go for the center mass, as they call it in law enforcement? And by that, they would then maybe be able to argue, look, this was not an attempt to kill him directly, or the defense would probably want to argue this was an actual attempt to kill him. But of course, it just sort of misses the entire point, which is police officers, when they fire their weapon, they're trained to take the person down. They're not trained to shoot him in the leg. They're not trained to shoot him in the arm and try to disable him. People ask that all the time. Why don't the police just try to disable the person? Because if they're considered a threat, law enforcement's experience, vast experience over decades and decades, tells them that the only way to neutralize the threat is to take the person down, and that's shots at center mass. So while they're picking it apart, I'm not sure it'll matter in the end.
We've got a recross-examination happening right now of the medical examiner on the stand in the Jason Van Dyke case, so let's go back in. The defense in the Cody Lott case really getting into the nitty-gritty about the defendant's mental state. Francey Hakes, an attorney, is with me here on the Law&Crime Network. Francey, I know that you're not buying the mental health defense in this case, but I've got to give the defense credit. They're really trying to walk jurors point by point through the facts that could lead jurors to such a conclusion.
Well, they are, Aaron, but you know what was so interesting? I took some notes during his closing argument, and one of the things he said to me that was really significant and wholly inconsistent with insanity is that the defendant hid his mental condition from his parents. You can't hide insanity from the people that you're living with. And then in the next breath, he says, but he was insane at the time and he's insane now. Hiding a mental condition suggests an ability to reason that is wholly inconsistent with being insane, in the sense that you cannot understand right from wrong. That makes no sense whatsoever. So even internally, the defense argument is inconsistent. But boy, he's doing his best.
You know, I think that's a great point. But obviously, this will boil down to what's going on in the minds of the jurors. This has been a very emotional case, and the prosecution brought that up time and time again during the prosecution's closing. We're going to be back with more live testimony and closing arguments in the Cody Lott case when we return from this quick break here on Law&Crime. We are listening to live testimony in the Jason Van Dyke murder case out of Chicago. A video analyst from the FBI is on the stand talking about how video works. 30 frames a second is the baseline of how quickly the pictures flash across the screen. We know this, those of us who work in broadcasting. Francey Hakes is with me here on the Law&Crime Network. She's an attorney who joins us regularly. So, Francey, what's the point of getting into explaining to jurors how slow motion video works?
Well, part of what a prosecutor has to do when they're putting up video evidence that has been changed in some way, that's been slowed down, we talked earlier about slow motion, they have to explain to the jury that while you can put these kind of techniques and tactics to work on video, it doesn't mean you're changing anything. So in other words, you can still believe your eyes when you watch the video. No one has edited it or changed the way it looks, only change the way it looks to our eyes so that we can perceive the important points the prosecutor wants to bring forth.
I think we're going to head back in for a little bit more live testimony in the Jason Van Dyke case now in Chicago. We are going to prepare to wrap up our broadcast day here on the Law&Crime Network, but of course you know there are two trials that remain live at this hour. The Jason Van Dyke case, which we're watching, and also closing arguments in the Cody Lott murder case out of Texas. Francey Hakes is here with me to help me wrap up the day. Francey, this closing argument in the Cody Lott case is going around and around and around, and prosecutors are reminding jurors, look, this guy went to his stepfather's place, got this .22 rifle, he racked it up, he loaded it before he even drove to the scene where he shot these teens. That is evidence of motive, it's intent, it's premeditation, it's everything all piled together. This is not an insanity defense. You seem to agree with the prosecutors on this one.
I do, Aaron, but the prosecutors have a tough burden. Their fear is that the jury says to themselves, I can't imagine killing a child. I don't understand why anyone would kill a child. Anyone who would kill a child is crazy. And now you have the defense trying to prove he is. So the prosecutor is desperate to make sure they don't believe that.
Well, the golden nugget that the defense handed to prosecutors in this case is this motive of having some kind of romantic interest in the young girl who he shot and killed, or some jealousy. Oh, I saw her walking. She appeared to have a boyfriend. Without the defendant's own statement, prosecutors would be left with very, very little in this case as far as motive. But we're just about out of time. Francey Hakes, I want to thank you for joining us again today.
Thanks for having me, Aaron.
We are going to wrap up for the day. As I said, if you'd like to continue watching the Lott case from Texas, if you'd like to continue watching the Van Dyke case from Illinois, go to our website, lawandcrime.com. There you can see the raw feeds as they come into us. This is Aaron Keller for the Law and Crime Network. We appreciate you joining us today. We'll be back live tomorrow morning.